Where is cannabis legal in the United States? That sounds like a simple question, but here's the part that surprises people later. Because cannabis can be legal in a state, illegal under federal law, permitted for possession but not transport, allowed for medical use but not employment protection, and enforced differently depending on where you are standing when a police officer decides to act. And that difference is where cases turn. Earlier I mentioned that the answer depends on where you are standing. We'll come back to that, because Virginia treats that question very differently than most people expect. Here's the counterintuitive legal fact or misconception. Most people believe cannabis legality works like a map. Green states mean legal. Red states mean illegal. Well, that's legally true, yet operationally misleading. Because legality in the U.S. is not a single rule. It's a stack of permissions, exceptions, and enforcement thresholds layered on top of each other. And the moment you cross a state line, or interact with an employer, landlord, or local government, that stack changes. This is where most people stop learning. And this is where problems start. Let's challenge a belief most of us likely hold. If you believe that cannabis being legal in one state protects you everywhere else, or that federal legalization would instantly override state enforcement, or that Virginia's decriminalization means cannabis is treated like alcohol. Well, that belief doesn't survive contact with how the law is actually applied. And the reason it doesn't survive has less to do with cannabis itself, and more to do with how American federalism works. Welcome to Norfolk, Virginia Cannabis Hub, where we focus on Virginia-specific cannabis law, local governance, and regulatory clarity, so residents, business owners, and communities understand what the law actually says, not just what headlines suggest. Today we're answering one question, but answering it correctly. Where is cannabis legal under United States law today? What we will cover. How cannabis legality is structured across all 50 states. Why federal law still controls outcomes in certain situations. How Virginia fits into this national framework. What we will not cover. How to use cannabis. How to buy or sell cannabis. Any lifestyle or promotional discussion. This is legal analysis. Compliance only. And as we go, pay attention to how often the answer changes depending on who is asking and why. Here's the context. Cannabis law in the United States evolved backward. Instead of federal legalization followed by state regulation, states moved first, one at a time, while federal law stayed still. That created three overlapping systems. Federal prohibition under the Controlled Substances Act. State-level legalization or decriminalization. Local enforcement discretion layered on top. Virginia sits squarely inside that overlap. And because it does, Virginians often assume protections that don't actually exist. That assumption matters, because enforcement doesn't follow headlines. Here's the legal explanation. At the federal level, cannabis remains a Schedule I controlled substance. That hasn't changed. States, however, fall into several legal categories. Full adult use legalization. Medical-only legalization. Decriminalization without legalization. Near total prohibition. Now, here's where the confusion starts. State legalization does not erase federal authority. It simply limits how the state chooses to enforce its own laws. That sounds abstract, but let me rephrase that more clearly. A state can decide not to punish cannabis conduct under state law, but it cannot authorize conduct that federal law still prohibits. That distinction is accurate on paper, risky in practice. So, where is cannabis legal, on paper? Now, this is the point where people usually want a straight answer. Which states are legal, and which ones aren't? So let's give that answer, carefully. As of today, states generally fall into four categories. First, adult use legalization. States like California, Colorado, Oregon, Washington, Massachusetts, New York, Illinois, and others allow adult possession under state law. Second, medical-only legalization. States such as Florida, Pennsylvania, Ohio, and Utah permit cannabis only under a regulated medical framework. Third, decriminalized but not legalized states. This is where Virginia sits, alongside a small number of others, where possession may not trigger criminal penalties, but the substance itself is not fully legal. Several states have decriminalized small amounts of cannabis, meaning limited civil penalties, yet none of them have full adult use legalization. These include Hawaii, Louisiana, Mississippi, New Hampshire, North Carolina, and North Dakota, and in a borderline case Nebraska has reduced penalties without a full adult use structure. That sounds like legal acceptance, but decriminalization is not the same as full legalization under state law, and it certainly does not change federal status. And finally, prohibition states, where cannabis remains illegal under both state and federal law. Yes, a few states still maintain near-total prohibition under their own laws. As of 2026, states such as Idaho, Kansas, South Carolina, and Wyoming have not enacted broad medical or adult-use cannabis programs, meaning possession, sale, or cultivation remains subject to criminal penalties under state law. That doesn't make federal law irrelevant, but it does mean that in those jurisdictions, the state hasn't carved out exceptions the way others have. Now, so, that sounds like clarity. But this is where the map stops helping. Because those categories describe permission, not protection. And that difference matters more than the list itself. Because the moment you ask legal for what, the answer changes again. And this is where enforcement and consequences start to diverge. How enforcement works. Cannabis enforcement depends on who has jurisdiction at the moment enforcement begins. Local police enforce state law, federal agencies enforce federal law, employers enforce workplace policy, landlords enforce lease terms. And none of those systems are required to align. Lab reports don't decide legality by themselves, packaging doesn't decide legality, the dispensary receipt doesn't decide legality. What decides legality is location, authority, purpose of the interaction. This is where enforcement changes the outcome. Who this affects. Consumers, especially travelers who assume legality follows them across state lines. Retailers, who may be compliant under state law but exposed under federal or banking rules. Local governments, who must reconcile zoning, nuisance, and public safety obligations. Medical cannabis participants, who often assume medical status overrides employment or housing rules. It does not automatically. Each group encounters a different legal reality, even when the product is identical. Why this matters? This matters for public safety because enforcement inconsistency erodes trust. It matters for regulatory clarity because unclear law invites uneven application. And it matters legally, because outcomes hinge on interpretation, not intent. People are rarely punished for what they thought the law was. They're punished based on how the law is applied. Here's a scenario. Earlier I mentioned that legality depends on where you are standing. Now let's return to that. Imagine a Virginia resident legally possessing cannabis under Virginia law. Scenario 1, they possess it at home. No issue under state law. Scenario 2, they transport it across state lines, even into another legal state. That single change triggers federal jurisdiction. Same product. Same person. Different outcome. This is where that issue becomes clear. Virginia legality does not travel. Federal authority does. And once you see that, the map stops being helpful. Now, let's take the same Virginia resident, but place them in a different system entirely. Not law enforcement. Not transportation. Employment. Imagine a Virginia worker in a safety-sensitive role. The employer operates entirely within Virginia. No federal contracts. No interstate travel. Virginia law allows adult possession. Virginia law restricts employer discipline in certain circumstances. So, on paper, this looks protected. But here's where the outcome diverges. A workplace incident occurs. Nothing dramatic. No injury. Just a routine post-incident review. A drug test follows, not because cannabis is illegal, but because policy allows it. Now let me rephrase this carefully, because this is where people misunderstand the protection. Virginia law limits automatic discipline. It does not prohibit investigation. And it does not prevent policy-based consequences tied to impairment, safety, or liability. That distinction matters, because that matters legally. In one outcome, the employer documents impairment indicators, aligns the decision with safety standards, and discipline stands. In another outcome, the employer relies only on presence, not performance, and the decision fails. Same law. Same substance. Different documentation. This is where cases turn. And this is why legality doesn't end the analysis, Here's what to watch next. In the next video, we'll look at what happens after cannabis is federally rescheduled, and why rescheduling does not mean what most people think it means for states like Virginia. Here's a question to think about. If cannabis legality depends on jurisdiction, not the substance itself, what happens when employers, landlords, and local governments become the deciding authority? That's the next unresolved legal question. Drop your thoughts in the comments, share what topics you want covered next, and if this helped clarify how cannabis law actually works, like, subscribe, and join the Norfolk City Cannabis Community for deeper discussion.